Okay, whoever's joining us on the phone with the last four digits of 3114, can you state your name, please?
Yeah, this is Dennis Dobson.
Okay, Mr. Dobson, I'm not ready for your case yet, so I'm just going to put you back on hold for right now, okay?
Thank you.
Okay, Ms. Mosher, are you able to hear me okay?
Yes, I can, Your Honor.
All right. I do not see your client in the waiting room. Have you had any contacts with him today?
Yeah, yes, Your Honor. I just spoke with him. He's a little delayed, but he should be here any moment.
Okay.
Your Honor, Mr. Earl is present.
Okay, great. All right, we'll go on the record in People versus Robert Earl. This is two files, file number 951498 and 951500. Counsel, if you would, please put your appearance on the record.
Yes, Lorna Mosier appearing on behalf of Legal Services of South Central Michigan. I'm here, P number 86550. I'm here with the defendant applicant, Mr. Robert Earl, who's seated to my right.
All right, so this is Mr. Earl's application to set aside some convictions in both of these cases. And I reviewed the files prior to the hearing today, including the applications. It does appear that Mr. Earl has met the technical requirements under the statute to have the conviction set aside. What remains for determination today is the final two criteria, which is that Mr. Earl's behavior and circumstances since the convictions would warrant having them set aside, and that it would be in the public interest to do so. Ms. Mosher, typically I don't take sworn testimony, but I do have counsel inquire of their client as to those last two factors. Are you prepared to do that today?
Yes, Your Honor, I can represent to you on some of those factors, or I can ask Mr. Earl directly to provide testimony.
I usually like the, I'd like to hear from the individual himself. So if you're ready, please proceed.
Understood. All right, good afternoon, Mr. Earl. First off, so are you currently employed?
Yes, I am. Flex and Gate.
Okay, and what type of employment is that?
It's an automotive supplier. I build front bumpers.
Okay, and the convictions at issue today were from about 30 years ago. Is that correct?
Yes.
And over the past 30 years, what types of work have you performed?
A lot of sales jobs, restaurant management jobs, and factory jobs.
All right, and have you ever been denied employment on the basis of your criminal record?
No. Well, yes, I have for a post office and for the casino because of that.
And when you applied for the casino, did they give you any more details about why they denied you?
Well, I'd lost several jobs because I didn't know what it was. The casino finally told me that it was because of this conviction, because The drug charges drop off after 5 years, but that first fraud conviction, that lasts a lifetime, and I wouldn't be able to get a job until I got that expunged.
Okay, and did they say whether or not they wanted to hire you?
It said they absolutely would.
Okay, and so since your convictions, have you purchased a home?
Yes, I have 8 years ago.
8 years. And can you describe your relationship to your neighbors?
Love my neighbors, very good relationship with Paul and Elaine Spitzley. Also used to be with the Cornells, even Boyd, but Boyd unfortunately died last year. He was like a second father to me.
And thank you. And in terms of the convictions that issued today and some of the others on your record previously, these convictions involved cocaine, is that correct?
Yes, it did.
Okay, and then when was the last time that you used cocaine?
20 years ago. That period between 30 and 20 years was a 10-year period. My parents died off, and I spiraled downwards because of that.
And about when did you, I guess, let me ask it a different way. Do you use alcohol?
No, not anymore.
And about how long have you maintained your sobriety from alcohol?
Been a good 10 years now.
All right. And then why is it that you're seeking the court to set aside these convictions?
So I can attain the better jobs. It's a later stage in my life right now. I need to be able to get a good job.
Okay. Is there anything else you would like the judge to know about this conviction?
Just that I've been on the straight and narrow for the last 20 years, since I got out in 2007. I immediately paid off all my fines and stuff within the first year. I've just strived to be a good person all around, be productive, and do the right thing from now on.
Okay. I have no further questions, Your Honor.
All right, thank you. The court notes that the prosecution and the Attorney General both have had an opportunity to contest the applications. Neither side is contesting the relief requested by Mr. Earl. Again, I've reviewed the file. I've listened very carefully to what Mr. Earl's had to say here on the record today. In looking at the file, he did have some issues subsequent to these two charges, which occurred in 1995. But as he's indicated here, and as the file reflects, it's been nonetheless still about 20 years since his most recent issue. So Mr. Earl clearly from his record has turned a corner. It's apparent that he has not had any contact with law enforcement of record in a substantial period of time, and that he's moved on from that period of his life. So the court finds that his behavior and circumstances since the convictions would warrant having them set aside. The court also finds that Mr. Earl's statements that he wishes to obtain different and better employment, but has been hindered in doing that because of these convictions. The court finds that it is in the public interest for individuals to pursue better and more gainful employment to support themselves, their families, to pay taxes and things that benefit the entire community. So the court finds it would be in the public's interest to set aside these convictions so that Mr. Earl can pursue those. So for all those reasons, the court finds that the final two criteria have been met. The court will grant the application as to both convictions. Ms. Mosher, I note that there was an order prepared and submitted along with the applications. I've signed that order. So if you just want to contact the clerk's office to make arrangements to get a copy of that for your records and for Mr. Earl. Ms. Mosher, anything else that I can address for your side here today?
No, Your Honor, I think that's covered it. I sincerely appreciate it.
Thank you.
Thank you, and good luck to you going forward, Mr. Earl.
Thank you, sir.
You're free to disconnect, Ms. Mosher.
Thank you.
Okay, Mr. Dobson, are you still there?
Yes, sir.
Okay, just one moment. All right, we have Mr. O'Mara connected, so we'll go on the record in file number 20-13517, Dan Woods property versus Dobson. We have Mr. O'Mara present on behalf of his client. We have Mr. Dobson present by phone on his own behalf. This was set for a status conference today. I believe at the last hearing, Mr. Zerhoff had withdrawn from his representation. Mr. Dobson was granted a period of time to obtain counsel. Mr. Dobson, can you speak to that for me, please?
Yes, Your Honor. We're currently in the process of retaining Posnick, Dyer, Tanner, Shevsky, and Thompson. We're getting them the information, and the first available meeting they have for me to get in is July 24th. They've already been sent over the stuff, but that's the first available they have where they can review it and take me on as a client.
Okay, so what are you asking the court to do today?
If you could just extend the meeting and give me, till after July 24th to have them, they will be my new counsel after July 24th. We have a meeting on July 24th then they will take us on.
All right, Mr. O'Mara.
I mean, I would rather him have counsel, to be honest. I mean, if we're going to be moving forward, I think we're going to get some trial dates. I do, and I would, I don't want to, I guess, wait for trial, but I do plan on filing another motion, predicated on just the fact that there's some information I obtained from the state that Mr. Dobson was not a licensed broker of elk. There's no record of him ever having a broker's license. So in terms of his breach of contract or those claims, it would essentially, our theory would be a legal contract to begin with. The underlying, it was based upon him being a broker, and he was not a licensed broker at the time. So I do plan on filing another motion, hoping to kind of streamline the case a little, but at the same time, I get at the court, you've had this for quite a few years now. We could just set a trial date as well.
All right, I think, I guess here's what we'll do. Mr. O'Mara, number one, I think you should file that motion.
Okay.
Like whenever you have that ready, because there's no reason why we can't get that filed and set for hearing.
Okay.
To keep things at least moving along in that regard. Mr. Dobson, I will schedule this for another status conference next month. So when you have your meeting with your attorneys, you need to let them know that they need to file an appearance and they need to get in this case officially so that they can get notices from the court. And as Mr. O'Mara indicated, this case has been pending for a long time and there needs to be resolution.
Yes, I realize that, Your Honor.
At the next hearing, I'm going to go forward with scheduling the case, whether you have counsel or not. By that point, I think there will have been a fair opportunity for you to obtain counsel.
Yes,
hopefully
we will have it by then.
But if they're not, you need to know that we're going to go forward with this case one way or the other at that point. And again, Mr. O'Mara, I think anytime you want to file that motion, we can get that moving as well.
Yeah, I just wanted, I know we already filed the motion. I want to kind of check with the court first. So yeah, I'll get that filed as soon as possible.
All right, and so the next notice the parties will get will be for that status conference. That'll go out and we'll go from there. Mr. Dobson, do you have any questions at all?
No, Your Honor. Thank you very much.
Mr. O'Mara, anything further for the record today?
Real quick, I go once a year. I take my family on a vacation from the 11th to the 15th. I'll be gone of August. So it's just a once a year thing. I have to do it. I got 2 boys. They love it. So if we could not schedule it from the 11th to the 15th, that'd be appreciated. I can bring my computer. I mean, I've done it before. I'd rather not.
It won't be during those dates. I can tell you that right now.
Thank you so much. Appreciate it.
You'll be good. Okay, very good. Thank you. You're both free to disconnect on this file.
Thank you, Your Honor.
Thank you.
out, so I thought that might be one of them, but. Just keeping me on my toes.
All right, sir, what case are you appearing on today?
The one about Justin Lane and Liz Kibbe for the
Okay,
house
what's your
on
name?
Monty Bingham.
Are you, all right, are you named party in the case?
No, I'm renting the house that is the one that's under the court case.
Okay. I'm just gonna put you back on hold for a minute, all right?
All right.
All right, counsel, I'm just waiting for your opposing counsel to sign in and then we'll get started with your hearing. If you could just stay on the line.
Thank you very much, Your Honor.
Thank you. Mr. Dasons, I'm still waiting for your opposing counsel, so I have another 2 o'clock that I'm gonna take in front of your case, and then, I'll call yours, okay?
Sounds good. Thank you, Judge.
All right, thank you. Mr. Lane, are you there?
Yep.
Okay, we'll go on the record in, this is Kibbe versus Lane, file number 2414643. The record should reflect the defendant, Mr. Lane, is present. And this was set as a status conference in this case. Back in May, there was a motion for default judgment, which the court granted. And Mr. Lane, you're given an opportunity at that hearing to obtain counsel or seek to set aside the default in some way. Based on what I'm seeing in the file, that has not occurred. So I think at this point, the court is going to enter a judgment, default judgment. Is there anything you'd like to say in that regard?
I did talk to a lawyer. He said something about a retainer. And he was wondering if it could get pushed back. Adjourned, I mean, that's what he said, adjourned. Because he looked at the information on there and he says it looks like there'll be another case, so he wasn't too serious about it. So we're gonna meet up this week about the retainer.
Yeah, so we had this hearing back on May 6th, so it's been 2 months now. If you were gonna do this, you needed to do it well before this time, so.
Yeah, I did it like 3 weeks ago. And he said he looked in the he somehow looked up on your guys' website and said it don't look like he said it looks like there's gonna be another court date, so he was trying to figure out all that. Yeah, I'm not for sure about what he meant with that.
Yeah, I don't know either. So I guess if you want to continue to consult with your attorney, that's fine. But the court's going to enter the judgment today, and and then it'll be up to you, I guess, through your counsel to try to have that set aside.
Okay. Yep, I think that's what he meant. Yep.
Okay. All right. Thank you. That's all for today. You're free to disconnect at this time.
Okay. Thank you. Bye.
Mr. Morgan, what case are you appearing on today?
The entire matter, Your Honor.
Antaya. Okay, gotcha. All right, Mr. Nason's Mr. Morgan, I'm going to put you back on hold for a few minutes.
Yeah, a little bit early. Thank you.
Thank you. Mr. Nason's I'm going to call your case. I still don't see counsel, and we're now a number of minutes being past the time. So this is Walker versus Northern Springs Management, file number 2514752. If you could just put your appearance on, please.
Yeah, good afternoon, Your Honor. Attorney Ryan Nason for the defendant.
Thank you. So this was set as a scheduling conference today. This is the first hearing before the court in this case. Have you had any contact with plaintiff's counsel?
Yes, Your Honor. We've conducted initial discovery. We've exchanged initial disclosures. We've exchanged written interrogatories, requests to produce, and both sides have answered those. We need some depositions and some medical records and probably a couple experts on each side, but we are progressing.
Okay. All right. I'm not sure why plaintiff's counsel isn't present today. I guess what I would do then, unless you have an objection, is to just set this again for another scheduling conference, assuming that there was some reasonable basis for plaintiff's counsel failure to appear today.
Yeah, I have my assistant trying to reach out to him, but she hasn't been able to get a hold of him yet. So while we were waiting,
All right,
I asked her to reach out.
No, thank you for that. So I'll just reset this. The court will send out a new notice of hearing and we'll go forward at that time.
Okay, yeah, no problem, Your Honor. Thank you.
Okay, thank you. You're free to disconnect.
Thank you, Judge.
Okay, council, just 1 minute here. Got to make sure I have all council in, and got a lot of names in my waiting room, so. All right, is all council here on the Antaya matter? Everybody that's in the courtroom? Is anybody not in here on that one?
Is there someone named Justin Hakla in the waiting room?
My name's Abram Miller, and I'm
Oh.
appearing on behalf of Pro Wrestle for Justin.
Sorry, I didn't know that. Sorry, Mr. Miller.
Appreciate you checking.
No, I appreciate it. You guys all are working with each other more than I am, so you all know who's involved. Okay, I think we've got everybody then. So we'll go on the record in the entire matter. This is file number 2213998. So if I can just have counsel kind of go around the horn, starting with the plaintiff, and put your appearances on, please.
Emily Peacock for the plaintiffs.
Good afternoon, Judge. This is Matt Thomas on behalf of Kalkaska, Dr. Craven, and Matt Schulich.
Good afternoon, Your Honor. Nick Arteev on behalf of Munson Medical Center.
Good afternoon, Your Honor. Connor Morgan appearing on behalf of Danette Wells, PA, and Dr. Elizabeth Hunter and Sound and Patient Physicians.
Good afternoon, Your Honor. Abram Miller on behalf of defendant Dr. Saminsky and Northwestern Michigan Emergency Room Physicians.
All right, thank you. So this is set for a status conference in this matter today. I guess I want to put this out to counsel and whoever wants to jump in first, I guess, to kind of let me know where things are at now and where we need to go here going forward, or where you would all like to go.
Look at everybody jump up, Judge. I can jump in. I think we have completed a ton of depositions, and we're well into expert discovery. I believe the only outstanding expert for plaintiff, and Emily, you can correct me if I'm wrong, is your economist. And so we just need the economist. We have, I know, a slew of defense experts that have been noticed up. I know a bunch of mine, or actually we've had some defense experts completed. I think we have 2 defense neurosurgery experts that have been completed. Maybe some additional ones. I know there's a bunch more scheduled in the next several weeks to a month into August. I know there's a few more that need to be scheduled because everybody has their own experts. But we're moving along. It's just there's an awful lot in this case, Judge, multiple specialty areas. So we've been traveling around quite a bit, and but we're working hard on trying to get everything done and in a position.
All right, Ms. Peacock, on behalf of plaintiff, I mean, should we just kind of, I don't know, I mean, I'm looking at if discovery is still ongoing. Does everybody want the court to just allow some more time for that before we set further deadlines? And I understand, like, just from the motion practice we've had, I get that this is one of the more complicated cases that we're going to deal with, so.
Judge, that's a good suggestion.
Okay. How about a time frame? What do you think? Well, starting with you, Ms. Peacock.
Sure, I would just suggest that we check back in 3 months like we normally do, if that's okay with the court.
Okay. Does anybody have an objection to that, or want a shorter time frame or a longer time frame?
I think that's reasonable, Judge.
No objection here, Your Honor.
No objection from our end, Your Honor. And I also just kind of wanted to indicate to the court that we've reached a confidential settlement with Ms. Peacock on behalf of the Munson defendants. So I guess we're hoping to finalize some of that release language. We've been going back and forth on it and hopefully get a dismissal on record for just the Munson defendants, or my client specifically.
Okay, all right. Okay, so that's how we'll proceed. I'll just put in the status conference order. The parties are ordered to continue with discovery and set for a status conference in about 90 days. And then we'll go from there. Is there anything else that anybody wants to request out of this status conference today?
Nothing from me, Your Honor.
And Judge, this is Matt Thomas. I don't have anything further of the court or ask anything further of the court right now. I appreciate the court's consideration that this is a complex case and we are working hard to trying to get discovery completed.
All right, thank you. Then that's how we'll proceed. The court will send out notice of the date and time of that next status conference, and all counsel in this file are free to disconnect at this time. Thank you.
Thank
Thank
you,
you, Your Honor.
Judge.
Thank you, Your Honor.
All right, counsel, can you state your appearance, please?
Yes, Your Honor. Gary Popovitz, appearing on behalf of Ms. Kibbe in the Kibbe v. Lane matter. This was set before Your Honor for motion of entry of default judgment back in May. I appeared, default judgment was granted. Mr. Lang appeared. I had some anxiety concerning the amount of damages requested and initially delayed the entry of the order. I needed to talk through some concerns with my client. She fully understood my concerns and authorized me to submit the order pursuant to your ruling rather than ask for relief or reconsideration of any of the pending action. So I think within the last 10 days or so, we had submitted a proposed default judgment under the 7-day rule to Your Honor. And I expect that once the clerk's office has processed that, the times ran, my expectation is it will be presented to you for signature and then it will close the matter out. And I apologize to the court and the clerk's office as to the lingering nature of this matter following the May 6th hearing. Again, it was simply me outthinking the room or overthinking things after the award of the default judgment and to what might be in my client's best interest. But again, I had a transparent discussion with her, explained to her my thoughts and concerns, and we collectively decided to proceed with the default judgment in the form that was granted at the May 6th hearing.
Okay, so yeah, I actually called the case at, I don't know, maybe 5 after 2. Mr. Lane was present. I had gone through the file and just indicated to him he had not, retained counsel. He had not filed anything to have the default set aside, which is one of the things that was discussed at that May 6th hearing. So I had the judgment. So I've entered that default judgment that was submitted earlier in June. And then I let him disconnect. So the judgment signed, that should be back to you sometime in the next few days.
Thank you, Your Honor. I apologize for my tardiness today too. I was in a mediation of another nature and I was distracted by it. And thankfully my assistant emailed and reminded me of the 2 o'clock. So I apologize for that, but thank you for handling it. And thank you for and not necessarily recalling it, but addressing me or updating me after my tardiness. So I appreciate that.
Okay, thank you. And you're free to disconnect.
All right. Thank you, Your Honor. Have a good afternoon.
Crampton.
Oh, no, that song's gonna be stuck in my head.
Ma'am, is your name Robin Crampton?
It is.
Okay, we'll go on the record in Crampton versus Crampton. This is file number 2514677. Mr. Cadet, are you appearing on behalf of Ms. Crampton today?
Yes, Your Honor, standing in for Attorney Angel Anderson.
Okay, I have this set for entry of a default judgment of divorce. Is that how you wanted to proceed, Mr. Cadet?
Yes, please, Your Honor.
Okay, so Ms. Crampton, I'm going to place you under oath. Could you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you. You can lower your hand, and Mr. Cadet, whenever you're ready.
Thank you, Your Honor. Will you state your name, please?
Robin Annette Crampton.
Ms. Crampton, are you married to Sean Robert Crampton?
Unfortunately, yes.
And did you file a complaint for divorce against him on or about January 6, 2025?
I indeed did.
At the time that you filed your complaint for divorce, were you a resident of Kalkaska County for 10 days?
I was.
And at the time that you filed your complaint for divorce, were you a resident of the state of Michigan for 180 days?
Yes.
And were you married to Sean Robert Crampton on April 27th, 2000 in Bel Air,
Correct.
Michigan by a person
Yes.
authorized to perform marriages?
Yes.
Do you have any minor children born or adopted during your marriage?
Not at this time, no.
Does that mean that all children born or adopted during this marriage are now adults?
Yes.
Are you currently pregnant?
No.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
That is correct.
Have you had an opportunity to review and sign a proposed default judgment of divorce in this case?
Yes.
And do you believe the property division represented in that proposed default judgment of divorce represents a fair and equitable property division?
Yes.
And in this proposed default judgment of divorce, have you do you understand that spousal support, if the court enters this judgment, is forever barred and neither of you can come back in the future and seek spousal support from each other?
Yes.
In this default judgment of divorce, are you also asking that your name be restored to Robin Annette Gifford?
Yes, please.
And is it your wish at this time that the court enter this default judgment of divorce?
Yes, please.
All right, thank you. Prior to the hearing, I had an opportunity to review the file. It does appear that Mr. Crampton was personally served with the summons and complaint back in February. He did not file any answer or otherwise defend. He was defaulted at the end of March and was mailed notice of the entry of that default, as well as notice of the date and time for today's hearing. He did not appear at today's hearing, which was set for 2:15. It's now 2:33. The court has heard the testimony of Ms. Crampton, finds that it meets the statutory grounds for divorce. So the court will grant the divorce, and I've signed the default judgment as presented by counsel. Mr. Cadet, is there anything else that I can address for your side today?
No, thank you, Your Honor.
Thank you, Your Honor.
Thank you. You're welcome, and all parties on this file are free to disconnect.
Thank you.
right, and thanks for your patience. So this is Wright versus Weaver, file number 24-14403, and can you put your appearance on, please?
Thank you, Your Honor. Good afternoon, Lauren Kreinberg appearing on behalf of plaintiff Mr. Jason Wright, who is not present in the courtroom today.
All right, and when I have this, this is a show cause today. Was this originally a debtor exam?
It was, Your Honor. Just to give the court a little bit of insight as to what's happening, or what I believe is happening today. My partner, Mr. Elkhart, sent written correspondence to the Antrim County Sheriff's Office on June 16th of 2025, essentially to ask them to serve the defendant, in this case, Mr. Weaver. Staff from my office this morning reached out to the Antrim County Sheriff's Office, and it's our understanding that Mr. Weaver has not been served for purposes of today's hearing.
Okay. So do you want to just renotice this for a separate date?
If we could, Your Honor, that would be great.
Okay, so yeah, I'll just ask that you renotice this for August. And we'll proceed further if you're able to get service on Mr. Weaver. If he appears, then I'll swear him in and you can do what you need to do. And if not, we're going to go from there.
Thank you, Your Honor.
Thank you. Do you know if anybody's here on 245?
Yes, Mr. Goodman is here.
Okay. Sorry you had to come all this way just for that.
No worries. It's always nice to get out here. Good to see you, Judge.
You too.
Yeah. See you next time.
Right here.
Yep, right there is good. Shot. Terry, you know.
How you doing, Dave?
Good. How are you?
Pretty good. Hot out.
It is. You know if Miss Harper's out there?
Nobody else is.
Nobody else is.
Right.
All right, so we'll go on the record in Harper versus Goodman. This is file number 2514722. The record should reflect that Mr. Goodman is present here in the courtroom today. Ms. Harper is not present at the date and time set for the hearing. Mr. Goodman, this is your motion. You're asking the court to terminate this personal protection order. Is that right?
Yes, Your Honor.
Okay. So because Ms. Harper is the one who obtained this order, the burden is on her to go forward to show the court that it should stay in place. And because she's not here today, then she's not here to do that. So it would be my intention to grant your motion and terminate personal protection order. So I'm going to sign that order today. There's also a pending hearing on a violation because Ms. Harper's not here. The court is also going to dismiss that violation. You know if there's a bond?
The PR bond, sir.
It's a PR bond.
First College gave it back to me. I did 8 days in jail.
You didn't have to spend any money to get on the bond.
Your Honor, you gave me a PR bond back. So I see you did 8 days. And
Okay.
you understand? You explained it to me in Western County
Okay.
via Zoom.
Okay. So the court's going to dismiss the again dismiss the violation, and the court's going to terminate the personal protection order. I'll sign that order today. Okay.
Thank you, Your Honor.
Do you have any questions at all?
No, Your Honor.
Okay. Thank
Have a
you.
good day. Enjoy the weather.
What? Yeah, you too. I'm gonna hang on to this because I'm gonna do a separate order dismissing.
Oh, sure.
Okay. Right now. Just let me know when we're ready for the big 3:30 sentencing. Okay, we're on the record in People versus Richard Galt, file number 244943. If I can count, put your appearances on, please.
Your Honor, Ryan Ziegler on behalf of the people.
The yellow rabbit or Mertz on behalf of Mr. Galt, who's you seated to my left.
Thank you. This is the date and time set for sentencing hearing. The record should reflect Mr. Galt's present here in the courtroom today. Mr. Galt, have you had a chance to go through the pre-sentence report and talk to Mr. Germerke about that?
Judge, Mr. Galt indicates he's having a hard time hearing. I know in the past he's had headphones, and I didn't see any here, but.
All right, I'll make sure that I speak up.
Your Honor.
Mr. Galt, did you have a chance to go through the pre-sentence report with your attorney today?
Yes, sir.
Okay,
Your Honor, I want to withdraw my plea.
okay. What's your basis for that?
Well, Your Honor, will you bear with me for a minute, please? The 14th Amendment of the United States Constitution provides no person shall be deprived of life, liberty, limb, or property without due process of law. Okay? Now, I'm sure, Your Honor, that you're familiar with the great liberality standard. The United States Supreme Court in People versus Benchek, 360 Michigan 430104 NW2D 191. The Supreme Court in Benchek Supra, page 432, stated, generally, it is considered that there is no absolute right to withdrawal of a plea. But this court's decision suggests that the trial judge's discretion be exercised with great liberality when the motion is made prior to sentence or commencement of trial. I have a motion here with me today, Your Honor. The same great liberality standard is to be applied when the request is to withdraw a plea of guilty or no contender plea. The Benchek and Prodigy are founded on the premise that the right to a jury trial is so important that that exercise of that right should not be impeded by belief in the defendant's guilt. Okay. Under Michigan Court Rule 6.310, withdrawal or vacation of plea, B, withdrawal after acceptance but before sentence. Number one, a plea may be withdrawn on defendant's motion or with the defendant's consent only in the interest of justice. In People versus Bonneville 291, Michigan App 363, 376, 804 NW2D 879, and Bonneville 291, Michigan App at 377 states the following. A motion to withdraw a plea before sentencing should only be granted if the defendant is able to show that withdrawal of the plea is in the interest of justice, meaning the defendant has to articulate a fair and just reason for withdrawing the plea. Fair and just reasons are an actual claim of innocence or a valid defense of the charge. Your Honor, I'm innocent. My valid defense of the charge is I have DNA results from 2 different forensics labs of Jessica's fingernail clippings that say there was multiple contributors to DNA found under her fingernails, but there was no match to my DNA. Again, there was no match to my DNA under her fingernails. I have the Verizon Wireless report showing cell phone coordinates proving that the descendant and I were in different counties when the 911 call was placed. The Verizon Wireless report also proves that the prosecution can't even place the descendant and I in the same county as each other for the days in question. That's right, Your Honor. The Verizon reports don't even put the descendant and I in the same county for the days the crime was taking place. I have the Verizon reports with me today. I have the DNA reports today with me for your review. I have medical reports with me today. Okay.
Mr. Galt, we had a trial. We had jurors. We were ready to go. Right?
I asked for a continuance to hire my own attorney, Your Honor, and you denied me a continuance.
Right. So we were ready to go to a trial. We had jurors here ready to hear your evidence that you have here with you today.
Your Honor.
You waived your right to that and you entered a plea on that day. So why should I now allow you to withdraw that plea?
Well, Your Honor, for several reasons. Okay. I filed 4 motions for substitutes of attorney that were denied. Mr. Guramuthi filed a motion and terminated his attorney-client relationship.
I know all of that.
2 months before trial.
That's not a reason for me to allow you to withdraw your plea. You knew all of that at the time you entered your plea.
A legitimate claim of innocence and a legitimate defense to the crime is reasons to allow me to withdraw my plea.
It's also reasons for you to go to the trial that we had ready and set with jurors here ready to go that morning.
With an attorney that terminated his relationship with me and we didn't prepare for trial, Your Honor.
You had plenty of opportunity. I'm not going to argue with you. You waived your right to that jury trial and your right to present all of that evidence that morning on the record. Right? I explained all your rights that morning, didn't I?
Can I finish reading this?
Didn't I explain all your rights that morning?
Yes.
Yeah. And you said you understood them?
I've
Right?
never signed an advice of rights form in relation to.
You stated on the record that you understood your rights, did you not?
Your Honor, I never signed an advice of rights.
That's
form
not my
in relation
question.
to this case.
That's not my question. My question is, you stated for the record that you understood all your rights, didn't you?
Your Honor, I have with me
Okay.
today medical reports that shows that Jessica died from internal bleeding due to cirrhosis of the liver. I have the medical reports right here with me for the family.
You had your opportunity to present all of that to a jury, and you declined that opportunity. You accepted a plea under the court rule that you cited, which is correct. NCR 6.310. You need to show that there was some type of error in the plea taking process. The plea taking process. That means what we did on the record that morning in taking the plea. So I need you to tell me what you think the error was in the plea taking process.
Well, Your Honor, I believe the error was the fact that you participated personally in the plea negotiations with my attorney and the prosecutor in the judge's chambers.
Okay.
According to People versus Green, People versus Cobb, and People versus Killebrew, it says we hold that sentencing concerns are appropriate subjects for plea bargaining. However, we hold that judges' roles in plea negotiations, the sentence bargaining included, is limited to consideration of the bargain between the defendant and the prosecutor. The judge may not become involved in the negotiations. Due to the nature of unequal bargaining positions of the judge and the defendant, any involvement in the negotiations transforms discussions into perceived coercion.
Yeah, I was not involved in the plea discussions.
Mr. Guramosi told me that you.
I asked the attorneys whether there was a plea agreement, and they indicated to me that you wished to enter into a plea agreement, which you confirmed on the record.
Mr. Guramosi told me that you were willing to allow me to make a plea of no contest to second-degree murder, a plea offer that was taken off the table 2 months prior. I was told that the judge is not going to allow you a continuance to hire your own attorney, but he has agreed to allow you to plead no contest to the second-degree murder plea agreement that was taken off the table 2 months prior.
And that's what we put on the record that morning.
Right, that you were involved in the
I was
negotiation.
not involved in the negotiations. Is that your only error that you're claiming in the plea process?
Other than the fact, Your Honor, that I have a legitimate claim of innocence and a legitimate, I am innocent and I have a valid defense to the charge.
Okay.
I have the DNA results. I have the
Thank
Verizon
you.
wireless
You stated your
report.
basis. I appreciate that. Mr. Grimurphy, is there any other legal argument you'd like to make on Mr. Galt's behalf?
Regarding the withdrawal plea, no, Judge. I've done my research. I've indicated Mr. Galt. Under the court rule, there was no legal error in taking of the plea. I've indicated Mr. Galt, the court was not involved in plea negotiations. Mr. Ziegler, the morning of trial, and the jurors were here, renewed a plea offer that Mr. Galt then accepted. That's the process of what occurred. And then we did ask the court if the court would allow Mr. Galt to enter a plea and release the jurors if he entered a plea. In my experience, once the jurors are here, this court has not allowed that to happen, and essentially at all plea cutoffs, essentially has treated that as a plea cutoff. And that certainly was not the case in this matter, because the court did allow, based on the renewal of the plea offer from Mr. Ziegler's office.
Correct. Okay, that's correct. Mr. Ziegler, any response to the people on the defendant's motion?
Just two things, Your Honor. As to what Mr. Gurmurthy just said, I would confirm for the record that the plea offer has been the same pretty much since the inception of this case. The court was not involved in any negotiation or amendments to the plea offer. The offer in this case has been and has always been for over a year, at least closer to a year and a half, murder second. So there was no court involvement in the negotiation, just that the court allowed us to take the plea in spite of the fact that there was a plea cutoff prior. In terms of the actual innocence argument, Your Honor, I don't have any of these Verizon reports the defendant is claiming to want to present. I don't have these independent reports that Mrs. Scott died of cirrhosis of the liver. Those are not the reports that were provided to me by Mr. Gurumurthy. It's the first I'm hearing of them. I don't believe they either exist or that they say what Mr. Galt implies they say, but in any event, I agree with the board. If he wanted to present that evidence, we had a trial date ready to go. He understood that, he chose to plea. There's no palpable error in the plea taking process. There's no interest of justice that would allow the withdrawal. And certainly I would further argue under 6.310B that the prosecution would be prejudiced by a withdrawal of that plea, as it took significant time and effort to prepare for that trial, which was going to span over 2 weeks and involved subpoenaing and coordinating over 30 or 35 witnesses on the prosecution side to appear to testify at that trial. Certainly allowing the defendant to withdraw the plea at this stage based on what the defendant has argued would create some prejudice to the people's side. So for those reasons, Your Honor, we'd ask the court deny the defendant's motion.
And Judge, I should make the record just clear that the only reports that I have, and I don't know what report Mr. Galt is indicating he has independent of what we have, is the defense's expert. If that's the report, then Mr. Ziegler has that report.
I have the medical.
Look, I'm not getting into evidentiary issues here today. This is way outside the scope of what the court would consider on a motion to withdraw a plea. So I appreciate your position, Mr. Gurumurthy. I'm not going to go further down this road because I feel it's a waste of time at this state. I'm not going to allow Mr. Galt to continue to waste the court and everybody else's time with arguments that aren't relevant. Under MCR 6.310B, the court can allow, and I view that as B1, I view this as a permissive type of situation where the court can allow in its discretion the defendant to withdraw a plea where it's in the interest of justice, and a claim of innocence certainly could qualify for that. I think it's clearly contemplated under those circumstances that where a defendant enters a plea and then makes a claim of actual innocence later, it's because of some type of new evidence that was discovered or some type of new circumstance that arose between the plea and the sentencing hearing. That then creates a question as to guilt or innocence and would allow the court to allow the defendant to withdraw the plea at that point, or some other type of situation such as fraud, duress, some other undue pressure brought to bear in the plea process or negotiations that in the interest of justice would require to withdraw the plea. I'm not hearing any of that today, other than Mr. Galt's continued claims of innocence, which again, he had a full and fair opportunity with a jury present to present those to a jury on the day of trial. And he chose on that day to enter the plea. Nothing has occurred in the interim which convinces the court that he is actually innocent or that it would be otherwise in the interest of justice to allow him to withdraw the plea. At this point, even if that were the case, for the reasons stated by Mr. Ziegler, there would be a high degree of prejudice to the people in allowing you to withdraw your plea at this late state when they were prepared, had all their witnesses ready to go for trial, and only because of your decision to accept a plea on that date did they not present those witnesses and that evidence and testimony. So for those reasons, to the extent it's within the discretion of the court finds that it should not exercise the discretion and allow you to withdraw your plea. The only other circumstances where you would have a right to withdraw your plea under 3.10B2 involves sentencing agreements or consecutive sentences. None of those are applicable in this case, with leaving the only other possible option as an error in the plea proceeding. I rewatched the plea hearing and all the proceedings and reviewed the transcripts in preparation for the sentencing hearing today. There wasn't anything in my view that either court or counsel did in the proceeding from a procedural standpoint in the taking of the plea on the morning of trial. An appellate court may someday disagree with me and find an error that I'm not seeing, but from my view, there was no procedural error in the taking of that plea. I'm convinced, Mr. Galt, that you were fully aware of what you were doing on that morning, that you were voluntarily and knowingly entering into that plea. I view your motion here today as a continuation of the strategy that you've employed throughout this case, which is to simply try to prolong things, to backtrack, to do everything that you can to prevent a final resolution in this case. And I view this motion as having really no merit and just another attempt on your part, just as demanding to go to trial, getting everybody prepared for trial, and then on the morning of trial deciding you want to enter a plea, now reversing your course on that. I don't find any valid legal argument. And again, I think it's a strategy on your part to try and create errors in this process for later for appellate purposes, or to try and delay it. So for those reasons, your motion is denied. The court is going to proceed with sentencing. Mr. Gurmurthy, are there any additions, deletions, or corrections to the pre-sentence report?
Can I just put one more thing
No,
on
you
record?
cannot. I'm sorry, I'm done.
I need to establish a record, Your
I'm
Honor.
sorry, I'm not going to allow you to do that. I've allowed you to state what you're going to state today. We're proceeding with the sentencing hearing. If you're going to continue to interrupt me during the process of this proceeding, they may have you removed and you can watch it on video. If you want to remain in
Your
the
Honor, due to
courtroom,
my current
you remain
medications that
quiet.
I'm on, I'm unable to make a spare of the moment logical decision first thing in the morning due to my medications. And I think it's in the interest of
I'm sorry.
justice
I'm
for the
sorry.
family to be able to see the
I'm
medical
sorry.
reports and the DNA results.
Sorry,
and the
we're not
private
doing
reports.
any of that today. We're proceeding with sentencing today. I'm going to give you one more opportunity to cooperate with the proceedings. If you don't, again, I'll make a decision about whether you need to be removed or not.
Quit looking at us, motherfucker.
All right. Let's take a break. Let's remove Mr. Dalton from the courtroom for a minute.
Man, I have the medical records if you want to see them. I love you, Stuart.
Just going to take a short recess. We'll come back on the record in about 5 minutes. Those of you that are present by Zoom, I'm just going to put you back into the waiting room, and then once we continue with the hearing, I'll bring you back in. back on the record, 1 second. So, ladies and gentlemen, and I want to make the record clear, defendant's not in the courtroom at this time. Ladies and gentlemen, I understand this is a difficult situation for all of you, and I understand the need and the desire and the inclination to want to respond to things that Mr. Galt is saying here in the courtroom today. And again, it's totally understandable. I can see where you're coming from, but it's really important that this hearing is carried on in a business-like way. And really, it's in your own best interest to ensure that Mr. Galt's sentence is upheld later, and interruptions and problems here in the courtroom are only going to complicate that. So you're not going to be helping your own positions in ensuring that Mr. Galt is sentenced and stays sentenced if there are problems here in the court during this hearing. So I'm going to ask that all of you please try to refrain from making any comments to him, having reactions to things that he says or does, and directing any comments or any outbursts towards him during the course of this hearing. Again, it's going to impede my ability to do what I need to do, what the court needs to do. It's going to impede my ability to make sure that Mr. Galt, that his sentence sticks later. If there are any of you that feel that you can't do that, and again, I understand that, I'm going to ask you to leave the courtroom, to have an opportunity to view the proceedings later if you want to do that. But again, if you don't feel like you can refrain from making comments or having outbursts here in the courtroom, I'm going to ask you to leave. Other than that, we're going to try and proceed again. If you can bring Mr. Galt out, please. Everyone, be seated. Thank you.
It goes off of the date of the offense.
Mr. Galt, I've got some instructions for you. I need to proceed with the sentencing hearing today. I need to proceed with the sentencing hearing today without interruptions, unless you are directed or given the opportunity to speak. I'm going to ask that you don't interrupt me. I'm also going to ask that you don't address anyone else here in the courtroom during this proceeding. That's happened already. I'm not going to allow that. If you continue to do that, then I'm going to have you removed from the courtroom and we'll proceed in a different way. Do you understand that?
Yes, sir.
All right. Mr. Gurmurthy, are there any additions, deletions, or corrections to the report?
Judge, there was just 2 corrections to the sentencing information report. That's the last page of the report.
Okay.
It indicates right in the middle in the top portion of the conviction information, the offense date. The amended information indicates that the offense date would be 10/25 to 10/30. I think we should reflect that on the offense date.
Is that correct? Mr.?
It is correct, Your Honor, that we filed an amended information in April of this year that reflects an offense date range of 10/25 to 10/30. So I don't have any objection to that correction.
All right, the court will order that correction then. Any others, Mr. Germer?
Just right below that, Judge, it indicates scored as of 10/30 of 23. I did speak with Mr. Ziegler about that as well and to the Department of Corrections. I think that the explanation I received is that it automatically puts that date from the original information and enters that in, but I think that needs to be modified as to the date of scoring. It couldn't have been scored that far back.
Mr. Ziegler?
Your Honor, I don't know what that field reflects, whether it's the date that the scoring was done by the probation agent, or whether it means scored as of, as in this is the last date where there was scorable conduct. I don't know, and I don't know that it really matters much in terms of the court's analysis, so I leave it to the court's discretion.
Mr. Wagner, can you?
I can't, I was just going back and looking at his old PSI, back from 2016, where it showed an offense date of 11/21 and 15, and that populated as scored as of 11/21 and 15. So the only thing I can think of is like in our system where there was a date range, our last date range was 10/20 of 2023 or 10/30 of 2023. So it picked up that last date, but I could probably go back in this system and reflect it to 10/25 of 2023. Would that be correct?
Well, I think
Maybe offense date.
it should say scored as of, again, if the record is just clear, if it's scored as of the date of offense, then it would be that date range in the amended information. If it was scored as of when the report was prepared, then the date on the bottom of the report is 6/5 of 25.
It wouldn't be, it would go based upon the offense date.
Okay, so, yeah, all right,
And it would be, what did he say, 10/20?
5 to 10/30.
right.
Okay, so if that's in the case, if you go back and look at the two previous page, or the second page, second to the last page where it says date of offense, 10/27, 2023 in the BIR,
Yep,
that should probably be changed then to
10/25.
10/25.
Okay, so we'll make those corrections then.
And it might reflect somewhere else as well, but I can make those corrections.
Okay. Any other corrections, Mr. Germer?
No, sir.
Any challenges to the scoring of the guidelines?
No, sir.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
All right, I did receive one victim impact statement that I reviewed. Not sure the pronunciation. I don't know if it's Alice or Alec.
Alec Yeomans, Your Honor.
Alec, okay. So I did review that statement. I know we do have some victims that are present today by Zoom video. Do you know whether any or who would like to make statements today?
Your Honor, I believe Jennifer Yeomans wishes to address the court, and given the setup of the court and the camera over there, I would just ask the court's permission that she do it from the gallery.
Okay, Jennifer, can you raise your hand, please? Okay. You can make your statement right from there if you'd like. And can you just state your full name for the court?
My name's Jennifer Yeomans. I'm Jessica's sister. I guess I was lucky because Jessica would run to my house a lot and they got into their fights to relax. I think that dragging us out is just putting us through hell. You know what you did. They couldn't get one organ to stop bleeding. I would ask that just be sentenced, and I don't want him to ever hurt another person's life. I just don't know how he can sit there and say that he didn't do anything.
Thank you. Any other victims, Mr. Ziegler, that would like to address the court?
I don't believe so, Your Honor.
All right. Anything that you would like to say on behalf of the people for allocation?
Yes, Your Honor. Your Honor, this case has been pending for over a year and a half. I've poured countless hours into the investigation, the preliminary exam, the negotiations, the trial preparations. I've learned more about internal hemorrhaging and triage procedures than I ever cared to know before. And I will forever have the images from Jessica's autopsy burned into my brain. This has been one of the most violent, traumatic, and callous assault cases that I have dealt with in 8 years as a prosecuting attorney. There is so much to talk about regarding this case, Your Honor, and there's simply not enough time to condense a 2-week trial into a 10-minute elocution. Luckily, the PSI does a very good job of summarizing the facts, but there are a few details I just want to highlight about this case that I think demonstrate why a longer sentence is warranted. First, there's the nature of the offense itself, Your Honor. By all accounts, this was a vicious beating delivered by someone who has a long history of violence. Jessica's own statements, preserved in text, and her final coherent words to emergency medical personnel described it as a 3-day ordeal where she was bruised from head to toe and had multiple black eyes. The EMS personnel noted that her arms were covered in bruises when they arrived to get her into the ambulance. The emergency room nurses, Jessamine Boyd and Nicholas Mitchell, described Jessica as being covered in bruises. Nicholas Mitchell, a registered nurse there, said to Detective Bruzikowski that, quote, "This abuse was the worst he has seen," end quote, in 5 years as a registered nurse in the emergency room. Jessica's pain was so bad that upon arriving at the emergency room, she quickly became incoherent and began thrashing about, something the medical staff described in their reports as pain agitation. To my understanding, that means the pain was so bad she couldn't talk clearly, she couldn't think straight, she couldn't do anything but physically struggle against the pain. The medical records show that when Dr. Strell performed surgery and opened up her body, he, quote, "immediately found 9 liters of blood in the abdominal cavity," end quote. For reference, the human body typically has 5 liters of blood in it in total. They pumped so much blood into her that night, again, quoting Dr. Strell's report, quote, "We had exhausted all our blood product resources," end quote. They pumped every drop of blood that they had available at Munson into her to try and keep her alive. Her injuries were so severe it was not enough. The autopsy report showed multiple lacerations of the spleen, multiple recent bruises, and signs of strangulation. Probably the only positive thing I will say about the defendant today is that his plea spared the family from having to see these photographs displayed on the big screen here in the courtroom. Suffice to say, they depict bruising all over Jessica's body, to say nothing of the internal injuries. The guidelines can barely account for the significance of the trauma the victim suffered in this case. The second factor I want to address for the court is the defendant's reaction to hearing this news. The defendant didn't rush down to the hospital. He didn't call friends and family to get news. He doesn't go anywhere. He just goes into hiding. He tells multiple people he beat Jessica up, that he gave her a black eye, that he hit her in the ribs, etc. But he's adamant in his text messages that he did not kill her. When law enforcement detains his daughter, Sterling, she admits he's been hiding inside the residence with the door locked and that she's been taking supplies. She also admits the defendant told her he might have done it, that he hit Jessica in the ribs and it could have caused a puncture or internal bleeding. While the defendant is texting numerous friends telling them he didn't kill Jessica, a few of them mentioned to him that he has home security cameras and that those should help exonerate him, help him show that he didn't do any of this. However, when the police recover the home security system and have it analyzed, they found the system had been overwritten on October 27th and again on October 28th, and no videos before the 28th exist. The defendant proceeds to have an armed standoff with the police, where he is in possession of firearms and body armor, and luckily his daughter is able to talk him into coming out of the house and surrendering. The defendant's hiding from police and probable tampering with evidence suggests that he is just as guilty as Jessica claimed he was prior to her death. It also strongly suggests a lack of remorse and a willingness to defy and evade law enforcement. The defendant's behavior and attitude throughout this case has been deplorable. Third, I want to talk about the defendant's criminal history. At a glance, Your Honor, a record of 2 prior felonies and 15 misdemeanors might not jump off the page for this court. I know we've dealt with worse records on other cases in the past, just in terms of quantity. However, on closer inspection, the defendant's record is atrocious. He's quite possibly the worst serial domestic abuser I have ever encountered. The defendant has 5 prior domestic violence convictions and 2 prior assault and batteries. On the surface, that's already bad enough, but digging into his history of his victims reveals that he has repeatedly and continuously abused his domestic partners for over 20 years. The defendant was in a long-term relationship with Kimberly Rootbright. Their relationship produced 2 children. Kimberly told law enforcement the defendant used to be a hard worker, but started abusing controlled substances and started drinking, and he would become violent when he did so. She recounted multiple instances of assaults between the 2 of them. She recounted one incident where she was choked so hard she vomited afterwards. She said the defendant used fear and manipulation to get his way. After Richard and Kimberly broke up, Richard married Krista Galt. Krista had a similar story for law enforcement. Initially, the defendant treated her well, but he abused drugs and alcohol and would become violent. She also indicated that she had been choked by the defendant. They divorced in 2012 or 2013. Defendant then began dating the victim's sister, Rebecca Buck. Ms. Buck told law enforcement the defendant would choke her, and he was, quote, really good with the kidney shots, end quote. She told law enforcement she had been given black eyes and bruises by the defendant and had experienced verbal and psychological abuse from him. After Rebecca broke up with the defendant, he started dating the victim, Rebecca's sister, Jessica Scott. Everyone who was asked by law enforcement to describe the relationship described it as some version of rocky at best. Friends, family, neighbors, everyone had some reason to believe the defendant was either emotionally, verbally, or physically abusive with Jessica. Multiple people described hearing them fighting. Multiple people described seeing her with unexplained bruises. In fact, the small detail I found the most telling when talking to witnesses is that multiple people I spoke to told me Jessica often wore long sleeve shirts, even in warm weather. To me, that speaks to the fact that she was being regularly abused, and she was either ashamed to show those bruises or was being emotionally manipulated into keeping them hidden. This murder was the culmination of decades of substance abuse, unresolved trauma, and the normalization of domestic violence in the defendant's life. The defendant has engaged in the exact same behavior with 4 different women over a more than 20-year span. This is just simply the time that the victim bled internally and died as the result of the defendant's abusive behavior. It is not new or unique or uncharacteristic of him. It is exactly what everyone has come to expect from him. There's so many details in this case, Your Honor, I don't have time to fully explore. There's each and every message the defendant sent shortly after the assault to his friends and family, playing the victim. I wish I had time to read them all into the record, Your Honor, because they're a fascinating look into his psyche. I'll just note that to me, they smack of the kind of emotional manipulation others have characterized this relationship as suffering from. There's the fact that the morning Jessica went to the hospital, he messaged his friend Nate Kibbe and said he had to get out of the house before he, quote, killed this bitch. There's the gross manipulation of his daughter, which continued on throughout this case, having her send letters to witnesses, talk to people on his behalf, instructing her to dodge service, having her try to hire another lawyer literally the morning of trial. Just this week, yesterday, in fact, I learned that they have been having jail communications where they were discussing, blanking on this now. They were discussing some things about the case, having Sterling send medical reports, autopsy reports, DNA reports to the victims in this case, the family members of Jessica Scott, including the victims who are potentially going to be speaking at sentencing today, Your Honor, to try and influence, in my opinion, try and influence their statements to the court or to try and soften their views of the defendant. This just more characteristic manipulation that he engages in. I truly feel sorry for Sterling Galt because she's been a pawn in his games for the last year and a half. And I hope she can one day see what her father has done, not just to the victim of this case, but to her and to her mother and and to every woman that he's come into contact with. There's the defendant's stories or excuses he's told other people about Jessica's death. Maybe it was a blood clot, maybe it was an ex-boyfriend telling everyone she was fine when he left the house that morning, while knowing full well what he did to her. There's the picture he posted on Facebook of a highway sign that said lodging next right state prison, and he commented, "Hopefully I won't be seeing anything like that again," end quote. Literally the night Jessica died. I hope I have impressed upon the court one simple fact: the defendant is irredeemable. He is not going to be rehabilitated. He is not going to change his ways. He is not ever going to be a productive member of society. And if he is ever released, he will continue his pattern of preying on women that he has engaged in for over 20 years. That is who he is. Michigan does not have the death penalty for crimes like this, and I've always agreed with that. I don't think the state should have the power to take the lives of its citizens, and I don't accept any philosophical justification for retributive justice. But I do think that for people like the defendant, there is simply nothing else to do with them but to put them in prison for the rest of their lives and make sure they will never be able to do this to anyone else ever again. At some point, the peniological goal of deterrence means that we must prevent this person from ever being able to exercise their free will again, because they have demonstrated they cannot make any decisions that will not lead to abuse and to trauma and to death for their fellow citizens. I don't know what the defense will argue in terms of mitigation, Your Honor, but there is nothing that will bring Jessica back. There is nothing that will excuse the kind of injuries the defendant inflicted on her. The defendant's actions have brought him here. His history of violence before the crime, the brutal and unconscionable crime itself, and the defendant's behavior afterwards all lead me to believe there is no alternative but to sentence him to the maximum term the court can give. I urge the court to fashion a sentence that ensures the defendant will never leave prison until the day he dies. Thank you.
Thank you. Mr. Gurmurthy, anything on behalf of Mr. Galt?
Does Mr. Galt, in lieu of preserving his rights, has asked me not to allocate on his behalf, so I don't have anything to add or allocate on his behalf.
Mr. Galt, is there anything that you wanted to say? The record should reflect Mr. Galt was shaking his head no. I obviously had an opportunity to review the pre-sentence report. We've had a lot of different motions in this case reviewed, as I indicated earlier during this hearing. The transcripts from the preliminary exam that was part of the plea process, but I reviewed it as well as part of my consideration in sentencing. I've reviewed the file. Obviously, I've reviewed the pre-sentence report, which gives a very detailed account of the relevant facts in this case, and also provides a lot of information about you and your background, Mr. Galt, and your history and so forth. I do want to thank Ms. Yeomans for making the statement that she made here today. I always think it's important for victims to stand up and make a public statement, as difficult as that can be, especially under these types of circumstances. Number one, I think it's important for the court and the public to hear it. And number two, I think it's important for other victims to hear when they see someone have the courage to stand up and make a public statement about how a crime has affected them. So I appreciate your comments and the letter that was written, and the other individuals that have appeared on behalf of the victim in this case. The prosecutors talked a lot about the aggravating factors here, and I don't think I need to go through those again. I don't think, certainly the victim's family doesn't need to hear about it again. You're well aware of your conduct, Mr. Galt, and what you did to contribute to the death of Ms. Scott in this case. A judge that I respect and admire and has been a mentor to me once told me that the more heinous a crime is, the less a judge has to say at sentencing, because it's self-evident the effect that it's had and the degree of depravity that has occurred. And I think the facts as laid out by Mr. Ziegler during his allocution clearly established that. I also think from the standpoint of rehabilitation, your record is an absolute indicator to me that there is no possibility for your rehabilitation. Mr. Galt, you have engaged in this type of abusive conduct towards other individuals and towards your domestic partners, as Mr. Ziegler indicated, for over 20 years. I counted 6 prior domestic violence convictions and 5 prior assault and battery convictions. You've had 10 prior jail sentences, 2 prior prison sentences. You've been on probation for 8 times in your 56 years. That to me indicates a long pattern, a long history of engaging in the same conduct over and over again towards different partners. I fully agree with what Mr. Ziegler had to say in the sense that this unfortunately was the last individual that you had an opportunity to have access to and to abuse. And this, I think, could have happened to any of your prior partners. It happened to go too far in this case, but I think it could have happened in any of those other cases, and they're all probably lucky that it didn't. Unfortunately for Ms. Scott, she was not. I'm fully convinced that if you were ever to be released and engage in another domestic relationship, you would engage in this exact same conduct. And for those reasons, for the safety of the public, the safety of the community, I do think that a prison sentence at the top of the guidelines is absolutely appropriate. I think it's important that you're never allowed to have access to another individual again, that you have the opportunity to abuse in the way that you abused Ms. Scott and the other women that you've been involved with throughout your life. So for all those reasons, the court finds, again, that a sentence at the top of the guidelines is appropriate. The court will sentence you to 450 months. That's 37.5 years to 60 years in the Michigan Department of Corrections. You do have credit for 617 days served. There will be a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence. Provide you with an acknowledgement of those appellate rights. Murphy, if you can provide it.
Yes.
Just for the record, Mr. Galt has his appellate paperwork with him.
All right, thank you, Mr. Galt. You are remanded in the custody of the state this time.